Joe, just want to talk real fast about Terry Frisk for a second. We talked about investigative detentions for a few moments ago, and all this law comes out of Terry versus Ohio. And if the police have a reasonable and articulable suspicion to believe that someone has committed or is about to commit an offense, they have a right to detain that individual and question him or her with the idea that the police are going to either confirm or dispel whatever the suspicions were that they had. Again, it's not enough to arrest. They don't have probable cause, but they do have a reasonable and articulable suspicion. And this is really what gives them the authority to detain these individuals for investigative purposes. Now, during the course of this detention, if the police develop a reasonable and articulable suspicion to believe that the individual might be in possession of a weapon, something that can be harmful to the police, they can conduct a frisk of this individual to recover that weapon. This is a limited search, a pat down of the outer clothing and any other articles of clothing the individual has, a limited search for the express purpose of recovering weapons. Again, officer safety being the key issue here. Being mindful, though, that the search has to be predicated on a reasonable and articulable suspicion. So you really have two issues here. A, was there a reasonable articulable suspicion to detain this individual at the investigation's inception? And B, was there a reasonable articulable suspicion to pat this individual down for weapons? They're really two different inquiries. Now, having said that, kind of set the stage here, Joe, for what constitutes reasonable conduct by the police. What happened in State versus Carrillo?
Well, in State versus Carrillo, police pulled over a car. There was a front seat passenger. It was Mr. Carrillo. And during the stop, the officer went over to the front seat passenger and chided him for making, quote, excessive noise. He got him out of the car, patted him down, and found nothing. They were probably going to be detaining the driver, and they just wanted to make sure that no one in the car had a weapon. Now, that may have been their intent, but we'll see how that complies with the law. So the officer got him out of the car, patted him down, didn't remember, you can only pat someone down not to look for drugs, not to look for betting slips, but only to look for possible weapons, knives and guns, obviously being the two most likely, so that, the officers can go about their business doing in handling the driver. Now,
can I just stop you here for a second? I mean, when I do police training, I always tell the police, look, hard is what you've got to be concerned with. Things that are soft in there are not likely to hurt you. But when the police are conducting these frisks, very frequently they'll find contraband in the pockets of the individual they're patting down, and they'll recover drugs or other types of contraband. And this is stuff that gets admitted in evidence under the so-called plain feel exception to the warrant requirement, right? That's really what these cases come down to, is what do the police find when they're conducting this, the frisk of the individual. Their purpose has to be look for weapons, but sometimes inadvertently they'll find, drugs and other types of contraband. Agree?
Agreed. And in fact, in order to pat him down the first time, you have to have reasonable and articulable suspicion. Now, that's way less than probable cause. It's a suspicion, but it's one that is reasonable. And number two, that's articulable. And by that, we mean it's capable of being put into words. It's not, the French phrase, je ne sais quoi, I don't know what, but I just feel it. Well, that's not good enough. It has to be something more than that.
It's got to be more than a hunch, Joe. The thing, I got a feeling, I got a hunch. Many times police officers have really good hunches because they develop good instincts. But good instincts and hunches are not enough in this context. You have to have a suspicion is both reasonable and articulable, and when I say reasonable, not based on the officer's subjective beliefs. It has to be objectively reasonable. The whole Fourth Amendment doctrine is all based upon objective reasonableness. So anyway, what happened I'm going to use the Spanish pronunciation, Carrillo.
We know that they were pulled over, and the passenger was asked to escort it out of the car, and the officer had to have had a reasonable and articulable suspicion that he might have something on him that could hurt the officers, so he patted him down. He did not find anything in his initial pat down. A few minutes later, he went back over there and patted him down a second time. And the second time he found, voila, a gun, a .22 caliber revolver. And also in his pockets, he found a small bag of drugs.
Joe, I got to tell you something. If I was one of the cops out on the street in this thing, I would be furious, absolutely furious. You can't let this happen. This guy had a gun on him, and they didn't find it in the first search. I mean, just you'd be very, very angry if you were one of the officers out on this stop, because this has all the hallmark of deadly danger to the other police officers. Did you give
and I have
thought
to
to that,
tell you,
Joe?
if you're patting someone down, it's not like you're finding a needle or something. This is a handgun. It's heavy, it's metal. At the very least, it's 6 inches by 4 inches of heavy metal. How do you not find that in the pat down? Now, who knows? It might have been the time of this may have been in the winter and he had a heavy coat on. I don't know. But I don't know how you miss that. And God forbid that guy later on pulled the gun out and killed the guy's partner. Him missing that on the first pass would have caused incalculable issues for him going forward. But nonetheless, he went back in, patted him down again, and this time he found the gun.
And the
So
drugs.
the question here is, okay, maybe you did have reasonable and articulable suspicion to pat him down once. But having patted him down once and having found nothing, how is it that you could say that you had the right to go back and do it again? That's an intrusion into him a second time.
So
In
it
this
goes back
case-
to Joe. This is back to the same thing we've been talking about. These themes. Did the police officers act reasonably under the circumstances? Yes, there's an exception to the warrant requirement that allows the police to conduct these frisks. But is a secondary frisk reasonable under the state and federal constitutions? I think that's really what this comes down to in the context we're talking about. How did the appellate division deal with this?
Well, the appellate division looked at the testimony down below and the facts of the case. And what they said was, one of the officers said that the Carrillo was, while he was out of the car, was moving excessively and doing so while he was in the car. And he also saw a bottle of liquor and a small metal pipe with burnt residue in the car. When he got him out of the car and he had a chance to assess the entire situation, he said that he was moving up against the car, making unusual movements, and he became suspicious. So he went back and did a second pat down. Now, remember, a pat down is as minimal as you can get in terms of searches. He does find it the second time, and the officer also said that, he had a second sense when he saw the way that he was moving, that he may have been moving something around in his pants, and he thought he was hiding something. And that something he thought must be a weapon, because if you've already missed the drugs, you're probably not going to find them the second time, especially if it's a small quantity of drugs. He did not conduct a Terry pat down simply to discover drugs or paraphernalia, but he had a reasonable belief and one that he could articulate to the court that this person was potentially armed and dangerous. And the court said, listen, in order to achieve the same safety goal that motivated the first pat down, the officer can conduct a second one if the totality of the circumstances then present justify it. But new facts may also revive the need to pat the person down. In this case, the way the man was moving with his body against the car suggested that he was trying to reposition something in his pants. But even if those additional facts justified the first pat down, another key fact has to be added to the totality of the circumstances. The negative finding on the first one, they thought there was something there. They thought he must have something from the way he was acting, and they didn't find it the first time. And they thought, we need to take a second look at this because we're in even greater danger now. So they said they're mindful that court should not, set tests of sufficient suspicion that the individual is armed and presently dangerous too high, because you want to set it as a low bar, because you're talking about an inconvenience to the people that you're patting down, but a potential deadly consequence for officers if they're not allowed to do so.
So, Joe, two things that our viewers have to keep in mind when you're arguing these cases. Number one, that the courts are supposed to judge this based on objective reasonableness. The individual opinions and thoughts of the police officers are not relevant, okay? You look at it from an objective standpoint. Did the police act in an objectively reasonable manner? Number one. Number two, the courts will look at this based upon the totality of the circumstances. In other words, they don't just judge little tiny bits of the puzzle. They look at the entire mosaic to determine whether the police acted reasonably. Time of day, how many police officers versus how many people in the car? What's the attitude of the individuals? How are they reacting to the police? Individual pieces of evidence that the police had available to them, information the police knew at that time. In other words, you look at all the circumstances that were confronting the police to determine whether or not the police acted in an objectionably reasonable manner. And under the facts of this particular case, I guess the appellate is holding that there was nothing to prohibit the police, or let me just say, it was reasonable, objectively reasonable for the police to conduct a second pat down of this individual based upon the totality of the factors or the facts that they were confronted. Would you say that's a good explanation, Joe?
Yeah, you summed it up perfectly.